Welcome to Patent Shark. This presentation will introduce you to subject matter eligibility, or Section 101. Now let's get started. What is subject matter eligibility? And what is a 101 rejection? Section 101. Whoever invents or discovers any new and useful process, machine, manufacture, or composition of matter, or any new and useful improvement thereof, may obtain a patent for that, subject to conditions and requirements of this title. So there are three requirements to 101. The first one is a patent, or one patent, which means that you can only obtain one patent for each invention. And that is the basis for statutory double patenting rejections. The second requirement, useful. The invention must have a specific, substantial, and credible utility, which is also called the utility requirement. And the third requirement is it has to fall under one of these categories as interpreted by the courts. And these categories are process, machine, manufacture, and composition of matter. And so we'll emphasize that one more time. There are four statutory categories of invention under Section 101, and it's worth repeating. They are process, machine, manufacture, or composition of matter, and any improvements thereof. Now, what categories are not included under Section 101? The courts have interpreted the categories to exclude laws of nature, natural phenomena, and abstract ideas. These three terms are typically used by the courts to cover the basic tools of scientific and technological work, such as scientific principles or any type of naturally occurring phenomena, mental process, and any type of mathematical algorithm that you may want to patent. So these are called judicial exceptions to 101. Now, at times, other terms are used to describe these judicial exceptions. So 101, categories. The claimed inventions that do not fall within those four statutory categories are not eligible for patenting. You cannot obtain a patent for that. But claimed inventions that do fall within those four statutory categories must still avoid the judicial exceptions in order to be eligible for a patent. And just as a very brief and quick example, a process claim would be ineligible, not eligible, if drawn to an abstract idea that has no practical application. Why don't we do an example? Here's a claim that does not fit within one of those four categories. The claim might start off in the preamble by stating, a paradigm for marketing software. And this comprises a marketing company that markets software from a plurality of different independent and autonomous software companies and carries out and pays for operations associated with marketing of software for all of said different independent and autonomous software companies in return for a share of the total income stream from the marketing of the software, etc., etc. This is an actual case in Ray Ferguson, and this is claim 24. The courts have determined that this claim is not patentable. And here's the explanation. Paradigm is a business model for an intangible marketing company, And the court said it's not a process because there's no series of steps. It's not a machine because it's not a concrete thing, consisting of parts or devices. It's not manufacture because it's not an article produced from raw or prepared materials. And it's not a composition of matter, a composition of substances or composite articles. None of that is found in this claim. So therefore, this claim is not eligible to receive a patent under Section 101. Here's example number 2. Let's say you have a signal with embedded supplemental data. And this signal is encoded in accordance with a given encoding process and selected samples of the signal representing the supplemental data, and at least one of the samples preceding the selected samples is different from the samples corresponding to the given encoding process. It sounds a little confusing, but this is an actual claim that was filed in Re Nugeten, and this was claim 14, and the courts determined that this was not a claim that deserved a patent. And here's the explanation why. A transitory propagating signal, like the claim before it, not within one of the four categories, okay? The transient signal, electric or electromagnetic transmission, is man-made and physical. So it exists in the real world, and it has tangible causes and effects. However, it was not found to qualify as a manufacturer or any other one of the statutory categories. What would be an eligible category? Well, organisms could fall under an eligible category. So non-naturally occurring, non-human, multicellular living organisms, including animals, are eligible for receiving a patent. However, claims directed to encompassing a human organism are not eligible. So what is a 101 rejection that you may see in an office action? Well, if a claim, under the broadest reasonable interpretation, covers an invention that does not fall within one of those four categories, then the examiner can issue a rejection under Section 101 of the patent law. Now, there could be several factors that weigh toward eligibility. Some of these may include recitation of a machine or transformation. Machine or transformation is very particular. If the machine or transformation meaningfully limits the execution of the steps somehow, now the machine may implement the claimed steps. The article may be transformed, and it's very particular. The article undergoes a change in the state or thing, or the article is transformed. The article that is being transformed is an object or some type of a substance. Now there's more factors, so let's go through a few more of these. Now the claim may be directed towards applying a law of nature, not the actual law of nature, but it's directed towards applying it. Now the law of nature may be practically applied, so that would be okay. The application of law of nature may meaningfully limit the execution of the steps. So these types of claims, if properly phrased, could pass muster under Section 101. Here's a few more factors. The claim is more than a mere statement of a general concept. Okay, that would not be allowed. So the claims may also describe a particular solution to a problem that you're trying to solve. The claim implements a concept in some type of a tangible way. And the performance of the steps may be observable or verifiable. In those types of cases, if the claims are properly written, you can get a patent for them. Now, here's some factors that weigh against eligibility that would not help you. If there's no recitation of some type of a machine or transformation, again, if there's insufficient recitation of a machine or transformation, involvement of machine transformation with the steps is merely nominally, insignificantly, or tangentially related to the performance of the steps. If the machine is generically recited such that it covers any machine that would be capable of claiming these steps, so it would just be too broadly stated in your claims. Machine is merely an object on which the method operates, and transformation involves only a change in position or location of the article. And again, if the article is merely a general concept, that would not pass muster. Here's some more factors. The claim is not directed to an application of a law of nature. If the claim would monopolize a natural force or patent a scientific fact, by claiming every mode of producing an effect of that law of nature, that would not be permissible. A law of nature is applied in a merely subjective determination, or a law of nature is merely nominally, insignificantly, or tangentially related to the performance of the steps. And again, these are more factors weighing against eligibility. And let's see a few more. If the claim is mere statement of a general concept, if the use of this concept, as expressed in the method, would basically grant a monopoly over the general concept. That's not something that is acceptable by the Patent Office. Also, if both known and unknown uses of the concept are covered and can be performed through any existing or future devised machinery, or without any apparatus or device or anything like that. Again, if the claims only state a problem to be solved, or if the general concept is disembodied, or if the mechanisms by which the steps are implemented is very subjective or just imperceptible. So, we talked about what is or what is not patent eligible. Let's just look at some very specific examples that the courts have dealt with. And these are examples of non-eligible subject matter. In other words, these concepts, as were written in a claim set, were not permissible for a patent. And let's take a look at these. Basic economic practices or theories. So if you're talking about hedge funding or insurance or financial transactions or anything like that, in very general terms, you're not going to be able to get a patent for that. If you're talking about basic legal theories, contracts, dispute resolution, rules of law, things like that will not also pass muster under Section 101. Mathematical concepts, algorithms, special relationships, geometry. As noted before, the application of such concepts is patentable, but not the actual concept, mathematical concept itself. Any type of mental activities are not patentable. Forming a judgment, making an observation, an evaluation, or giving an opinion. Also, interpersonal interactions or relationships, conversing, dating, teaching concepts, memorization, repetition. There's really no way to patent those types of things. Human behavior, if you're exercising or if you're wearing clothing or following some type of rule or some type of instruction set, that would also not be permissible. And last but not least, and this is just some of the examples that we have seen, instructing how businesses should be conducted. So once again, all these are non-eligible subject matter topics. Okay, Sharks, congratulations. You now have some very, very basic tools for understanding Section 101. And just for your information, we wanted to say that Section 101 has become very complicated in the last few years based on several court decisions, especially some Supreme Court decisions, and one of them being the Alice decision, which many of you may have heard of. So for now, this presentation will give you a good basic taste for 101. So, just stay positive and stick to it, and you'll understand this more and more as you practice this concept and you see it in your in your general practice on a day-to-day basis. Thank you very much, and have a good day.